South African Institute of Professional Accountants, that FICA, has questioned the constitutionality of the FICA Bill. FICA deliberated the constitutional integrity of the clause that and has submitted a letter to Parliament's Standing Committee on the Finance outlining its reservations. FICA raises questions on what it believes is the lack of specificity in the bill. It says it has reservations on the warrantless searches. It says there are definite circumstances where offenders may leverage delays in obtaining a search warrant to tamper with or destroy the crucial evidence. They also have concerns that are related to the lack of specificity about the conditions under which the warrantless searches can be executed. It goes on to say that it's in its current form, the amended clause threatens to violate Section 14 of the Bill of Rights, which states that everyone has the right to privacy, not to have their person, home or property searched, their possessions seized or the privacy of their communications infringed. FICA says it remains that a person's constitutional rights would already have been violated. On principle, no law should be passed, should be passed that would permit this eventuality. So what is the warrantless search all about? That FICA finds to be contentious. The amendment proposes that an inspector may enter premises without a warrant, either with consent from the person in charge, provided they are informed of their right to refusal, or if the inspector on reasonable grounds believes that a warrant would be issued anyway, and the delay in obtaining one would defeat the ends of justice. Well, joining me in studio to discuss this further is Ayanda Mabida, Company Secretary at the South African Institute of Professional Accountants, and also Mr. Mzwanele Manyu from the Progressive Professionals Forum is also here to discuss this issue. Very good afternoon to you guys. Thank you for joining us this afternoon. We'll start with you, Ayanda. Obviously, you've gone through the FICA bill. You've taken issue with certain parts of the bill. It's very detailed in the issues that you have taken upon the committee. Would you like to quickly take us through that and tell us exactly what you are finding to be very contentious in that?
Thank you very much for the question, Audrey, and thank you for having me here. Our stance is clear as FICA. We have specific concerns with regards to subsection C of the bill in its amendment. The provision provides that any inspector may enter the premises and do a search without a warrant on a reasonable belief. Our question is, how do you determine, how do you judge what a reasonable belief is?
Right.
We are opening that section up to abuse, and that is our concern, and that is what we have addressed with Parliament in January.
Okay, it sounds like it's a genuine problem, Mr. Manyu. I don't know how you take it. I mean, how do you draw the line between a reasonable doubt, or is it reasonable belief or suspicion? How do you gauge that?
Yeah, no, it's true. I mean, that's ambiguity. That's the ambiguity of this thing, because it puts the onus and the responsibility on a FICA inspector to say if he reasonably believes. I mean, what does that mean if he reasonably believes that if they don't do the warrant, if they don't do the search, something wrong is going to happen before they do the search, so they must go without a warrant. So it really is very, very subjective, unscientific, totally arbitrary. Yeah, so we are also...
It's very vague. That's what the problem is.
It is indeed very vague.
What are you hoping to... What do you want to see amended? What would you consider substantive or substantiated suspicion that would then warrant someone to have a warrant search, to go in and go into someone's premises to search whether their person or their telephone communications or their property?
Okay, thank you. What we've referred to in the submission to Parliament is the reference to the Anton Pillar Order, which is a remedy that is not often used in intellectual property matters, whereas you approach the courts without notice to the other party. You approach the court, you present your prima facie evidence to say, this is what I believe is happening. If we apply for warrants, there could be a tampering of the evidence, there could be disposal of the evidence, and then the court would determine whether or not a prima facie case exists. Now, that is what we would hope would happen. We believe that the Act or the bill should be expanded to include those grounds.
Right.
Yeah.
What does the Constitution say, Mr. Manyu, if you could just recall that for us when it comes to, protecting your rights of, not having someone just come into your place and search you? What does the Constitution say about that, and compared to what the FICA Bill is saying?
Yeah, no, look, this is a serious violation because the Constitution protects your right to privacy. It's actually very specific that to have your home searched and all of those things. This is what used to happen in apartheid days. So when this Bill of Rights was put in place, it was there to ensure that we don't get back to apartheid kind of approaches. So what this bill is doing is actually bringing apartheid in 2017. So it's really objectionable.
Well, the SIPA is not the first one to oppose the amendment bill, obviously with the issues that you've taken up with. But what options do you think the Parliamentary Committee on Finance has, and what is the remedial course besides the one that you've told us already? And what are the issues besides the one that you have mentioned now that you'd like to see amended?
Okay, for us, we've already specified the issue regarding to the constitutionality, but I understand that some bodies, including PPF, have specific other concerns with the bill.
So could you tell us that perhaps, Mr. Manyi?
No, quite a few issues. Firstly, the objects of the bill. One of the objects of the bill is that the bill seeks to dissolve a counter money laundering advisory council. This council is already provided for in the actual act, the FIC 2001 Act, the original act. Now, in this council, if you look at who sits there, it's defense, it's police, it's Department of Justice, it's treasury, everybody sits there. And the importance of that council is that because this whole bill, this whole act in the first place, is meant to be managing issues around money laundering, terrorist activity and all that. So therefore, if anybody picks up anything that is untoward, you would want your response units to be in place to have the correct executive authority to be able to act on this. Now, when you dissolve this, in fact, you're putting the country at risk, because when something happens, you then have to start phoning somebody that is not in the system, get the relevant authorities and what have you, totally unnecessary. So that dissolution of this counter money laundering advisory council, we think it's incorrect to dissolve it. That's the one thing.
Right.
Secondly, we think that these FIC inspectors, as they pick up whatever they pick up, they must conform with the law. We can't have a situation where the FIC inspectors pretend that they are security agents when they are not security agents. Both the constitution of the country and other legislation are very clear on this, that the duty of investigating, the duty of combating crime is the duty that is given to the police. Section 205, subsection 3 of the Constitution is very clear on this matter.
Right.
And then when you go to the actual legislation that deals with the matter, the National Intelligence Act of number 38 of 1994 lists all the various agencies that have got the mandate to do this investigative work, and FIC is not part of those agencies. What this bill seeks to do is to take the powers of those security agencies and give them to people that are not even trained to do criminal work and all that, and also give it to people that are not even vetted. The last thing that we need as a country is to have people fiddling with our accounts, people that aren't even vetted. For all we care, these people could themselves be part of international criminal syndicates. We don't know.
So I understand your point.
This is
Mr.
why it's
Manyi.
important that these people are actually vetted before they touch our finances.
Yeah, sounds like a very valid point. I just want to hear from you, Amanda. Just going back to what Mr. Manyi said, of course, your thoughts as well as SIPA. The issue of the amendments giving free will to the banks and other financial institutions, the danger that comes with that. Is that one of your issues, of course?
Yes, it's one of the issues, and it's also highlighted what I was saying is that they could look at other remedies where the judicial system, a magistrate or a judge, could have a look at that and say, is there reasonable ground? Is it justifiable for this search to occur? We don't believe that the private body, as he's correctly saying, should be left to their own device to decide this, or the inspector should be left to their own device to decide this, because you're providing something that's very good, that's progressive in South Africa, but now you are opening it up to abuse, and that's the fear that we have. It could be open to abuse, and that is why we're taking a stance and saying we have a duty to protect our members as SIPA, and this is what we are doing by raising our concerns.
All right, so the separation of duties should be very clear, and in this case it's a bit ambiguous. Anyone can, be given a duty that they could possibly abuse. The deadline.
Transgressing it.
Okay.
Transgressing that separation of powers.
That separation of powers, which you clearly stated to us just now. The deadline to sign the bill is in 2018. There's a chorus growing, obviously, that it must be signed now. Are you worried?
No,
Obviously.
we're not. We're actually happy that we're not worried. We don't understand what the urgency is. We are saying let's engage. Let all parties share their views on the matter, and then we must decide on a way forward that is beneficial to everyone in a democratic country. So we're not worried. We're saying, let us engage, give us enough time. Let's not rush the legislation because there's pressure from whichever body that has their own concerns.
All right.
And we agree with this because, in fact, FATF the Financial Action Task Force, the next time that South Africa is going to be inspected is 2019, end of the year 2019. So we've got all this time to be able to do this thing properly. So this rush is because actually banks have unlawfully started implementing this act. So we as PPF are saying this rush is because they want to cover their tracks, because some of our members in the Black Business Council have already got their accounts frozen or closed, and all of this without any proper explanation.
So are you saying you're not trusting the process that's happening with the committee, that they're not understanding the concerns, or they do understand the concerns that SIPA has and your organization has, Mr. Manyi, but you don't trust that they will take into consideration these concerns that you have, because they're trying to
worried about that committee.
Someone who's doing something in the banking sector?
I'm very worried about the committee, the finance committee. I'm very worried about it because they seem to be very mechanistic. They are worried about why didn't you come on this date and to make a submission. Now the time has passed, we have to move on. There's no such a thing. We cannot have a law that is violating the Constitution. The fact that we did not submit when they wanted us to submit, or did not participate at a particular juncture when they thought we should have participated, is neither here nor there. Because if the law was constitutional, there would be no issue. We are not arguing that we're not consulted. We are simply saying that the product is substandard. The product deserves to be withdrawn. The product deserves to be reconceptualized. This is what we're saying.
Okay. What other advice would you give to Parliament with regards to the FICA Bill, besides what you have already mentioned? What other issues would you advise for them going forward?
I think the very first thing that I would advise Parliament to do is to withdraw the bill, send it back to Cabinet, let Cabinet rediscuss the bill, let the powers that belong to various departments be apportioned appropriately. Let that be the case. Let the act, and also they must remove this additional thing that they have done, which is not required internationally. Internationally, what FATF has spoken about is PEP, politically exposed persons, and those people are listed. What this bill has done, it has gone beyond the call of duty. They have now included a lot of people in the private sector, which they have coined a new term, prominent influential persons, and your only crime is to just do business with government, then you are in the loop with your entire family, then your life changes. And once you are a PIP or a PEP, you are a PIP or a PEP for life. Why is it that we are getting ourselves into this situation? Countries that are participating in this thing of FATF have not signed the kinds of things that this bill wants us to do. In America, for instance, America said, we have our own FBI. Our FBI is doing this thing, so we don't need to do this thing that you want us to do in this particular way. So our advice is that let's adopt international practice, see what America has done, follow America. It's the biggest country in the world. Follow America.
They have experience.
Yeah.
And should the FICA Bill be passed as SIPA with your operations, how would this challenge you?
Oh,
not just your organization, but clients as well, who are obviously practice finances in their business or in their personal life.
That's basically what we're saying, that you are opening this up to abuse, and you're opening their business and their other operations to be impacted negatively with this. That is why we're saying, please can you go back, look at the provisions of the Act, rework them, taking into account all the consultations, all the comments that have been submitted, then come back to us and say, this is the amendments that we have looked at. So I agree partially with what Mr. Manyi is saying, that we need to go back to the drawing board and say, how will this work for everyone concerned?
Okay, you say agree with him partially. Is it my understanding there's certain things that you don't agree with what he's proposed?
No. In terms of the concerns that he's raised, he's highlighted three issues, Marat. We are concerned with the constitutionality with regards specifically that will affect our members. So that's why I'm saying partially.
Okay.
Yes.
Your submissions, did you manage to put them through to the committee in time? Have they been able to look through them?
Yes, they have, but we haven't received a response in that
regard. And when are you expecting for this to happen? Is there a timeline that they've given you?
No. As far as I'm concerned, no. We were just meant to submit by the 25th of January, which we have done, and they've received them. They've confirmed receipt.
Okay.
And we had public hearings, I think.
No, that's done.
That's done already. Yeah. So we're just waiting for feedback on how that will work.
Okay, Mr. Manyi, your submissions were late. I understand from how you were saying maybe you're given a timeline.
No, they were not late.
Okay.
What happened is when the bill was being knocked to shape, there was the public consultation process, which we did not go there as PPF on that process. And the reason we didn't go there is because the issues that we're raising were discussed. So we acted, we gave our we operated in good faith that parliamentarians are going to deal with these matters appropriately. So we trusted them. They are competent people. We had no reason to doubt them. So because they were alive to the issues, we thought they were going to deal with them. We're just disappointed at the end to say, what happened here? Why is this thing not dealt with? And yet it's not new stuff. I mean, the chairman would admit as well that these things have been raised, have been discussed before, but it's not enough to discuss them. What is important is to do something right after things have been raised. So to discuss them and then pretend as if they were not even raised is a problem.
Okay. Well, that's the discussion there on the FICA bill we had in the studio, SAIPA, that's represented there by Ayanda Mabida. And of course, Mr. Mzwanele Manyu was here from the Progressive Professional Forum. Tell us what you think of the FICA bill. Use our Twitter handle at ANN7TV. Of course, the FICA bill is up for discussion and proposals have been put through, and we'll see how that pans out. We'll keep you updated with regards to that. Well, it's time for a very short break. You're watching ANN7 Newsroom. Actually, that's a wrap of the program, ANN7 Newsroom. And of course, to all our viewers, happy Valentine's to you and yours, and of course from us, the ANN7 family. It's time for a short break. To stay tuned.